It is now my privilege to invite Honorable Mr. Justice Mian Hassan Aurangzeb, Judge of the Supreme Court of Pakistan, to address this august gathering. Sir.
Thank you very much. I feel privileged to have been invited to this August forum. Honorable Mr. Justice Shahid Waheed, Judge Supreme Court of Pakistan, Chairman Task Force on Alternative Dispute Resolution, Honorable Federal Minister for Law, Honorable Minister of State for Law, Honorable Judges, ladies and gentlemen, Assalamu alaikum. Pakistan today faces an insurmountable problem of case backlog and case workload. The alternative to this problem is seen in the alternative dispute resolution mechanisms, which should not be perceived by lawyers and judges as a threat to advocacy or judicial power, but a partner, an ally that is going to reduce this backlog and this caseload for the courts so that the courts can truly concentrate on adjudicating upon the true disputes that come before it. Today is the day that I wish to congratulate you who have completed the 40 hours of training and have developed a skill that many do not have, which is the skill of deriving from the confrontational and positional postures that are attained by disputing parties and distinguishing it from the true interest which, if given to a party, they will settle their dispute. To sift the grain from the chaff, so to speak. This ability of yours is then to be utilized in mediating disputes and making mediation embedded in our justice delivery system. Today, I take this opportunity to highlight 3 imperatives for mediation to be successful in Pakistan. The first is that we need an updated and a modern system of law and rules for alternative dispute resolution to be a part of the justice delivery system. More than 90 countries of the world have adopted the standardized method of resolving disputes by adopting the UNCITRAL model. India did it in 1996. We have an arbitration bill which has been recommended by the Law and Justice Commission to be made into a law so that this international standardization can take place. But because arbitration is a provincial subject, efforts have been made and steps have been taken under Article 144 and 147 of the Constitution so that the provincial assemblies can pass resolutions authorizing the federal legislature to legislate on this very important subject. I believe the provincial assemblies of Punjab and the provincial assembly of Balochistan have passed such resolutions. Those of the province of Sindh and the provincial assembly of Khyber Pakhtunkhwa are awaited. I am assured by the Ministry of Law that efforts are being made for this development to take place in the near future. And once this bill is enacted, it is made into a law, it will encourage foreign investment and will make the entrepreneurs of Pakistan, it will give them a safe and a fearless environment. Sir, since the past 3 years, 2022, when I got an opportunity to understand the system of mediation in the Republic of Turkey, and I was pleasantly surprised that in the short period of 8 years, when it was first introduced over there, more than 3 million cases had been resolved through a process of mediation. Since 2022, up until now, Pakistan has taken a quantum leap. We have provincial laws over the subject of mediation. The Ministry of Law, I believe, has notified more than 200 mediators. These are no ordinary lawyers. and none of you are also. You are experts in your field, whether it is with respect to the law in construction, whether it is revenue law, banking law, service laws, so on and so forth. We have experts as mediators now, sir. But a doctor needs to be referred patients. A lawyer needs to be referred clients. A mediator needs to be referred disputing parties. It's all very well to have all these mediators here in Pakistan, but we do not want them twiddling their thumbs. We want them to resolve disputes. And disputes are to be referred in two essential mechanisms. One is the pre-trial dispute, pre-litigation dispute, and the other, which we need to concentrate on, is the pending litigation referrals. Those referrals are to be made at the nascent stage of the dispute, which is the civil court, or the court where the dispute originates. In Islamabad, at least, we have issued practice directions where on the first date of hearing, when the file is complete, the consent of the parties have to be taken as to whether to refer the matter to mediation or not. And if that consent is not forthcoming, reasons have to be recorded on the order sheet. Those reasons are important because tomorrow, say for example, the matter is not referred to mediation by reason of an unreasonable withholding of the consent of one party, which ultimately loses, this fact will factor in the determination of costs. Speaking of costs, we have in Islamabad the Cost of Litigation Act 2017, which is a sea change from the earlier law. It is my view, sir, that in order for mediation to be made successful in Pakistan, we have to adopt the carrot and stick policy. The carrot being early resolution of disputes, speedy and cheap resolution of disputes. The stick being that if you unreasonably withhold your consent to mediate, tomorrow you will get the stick of costs. It happens in all civilized judicial systems that the costs follow the event. It is about time that we in Pakistan also resolve to do the same. The second very important aspect is that of developing an institutional capacity in Pakistan to cater for mediation. This institutional capacity has been developed, as I said earlier. We have more than 200 accredited mediators. Tomorrow, when you pass your assessment and are recommended by the accreditation committee, you will also be notified. We have laws in place, and the mediation centers have their own rules. So the institutional framework in Pakistan, sir, is very much in place. We also need to have a change in the hearts and minds in order for mediation to be made a success story. Why do we quote examples from the West? Why do we quote examples of Turkey? We need not go beyond the borders of Pakistan. And may I take this opportunity, sir, to tell you that in June 2024, I had the privilege of visiting Gilgit-Baltistan with judges of the Honorable High Court of Sindh to study their model of mediation. And what we learned over there is that the members of the Aga Khan International Conciliation and Arbitration Board, which caters for the Muslim Shia Ismaili Imami community, they have been the initiators and they have gone leaps and bounds ahead in developing mediation. That is not something that happened overnight. They have developed it since 1974. And we saw their records of 1974. They have perfected this art. Why I say that they have perfected this art, sir, is because during this visit, we also had the opportunity of visiting their civil courts. I was under the impression that we will be meeting a number of judges. We will be seeing civil judges and district judges and discussing their problems of backlog, sir. Sir, our visit there was very short because there was only one district judge and there was only one civil judge. Not because they were understaffed. It is only because the total pendency in the district court was 74 cases. The total pendency in the civil court was 147 cases. This is because in that area, 90% of the population belong to the Ismaili community, and it is His Highness the Aga Khan who has mandated for his community to resolve these disputes through a process of mediation. We do not need any mandate from any organization. We have the divine mandate from Allah. In Surah Hujurat, ayat number 10, tells us that all you Muslims are brothers amongst yourselves, and resolve the disputes and reconcile the disputes between two brothers and fear Allah so that His rahmat is on you. So it is a question of sawab, other than well-being of the community at large, that we must all resolve to work in tandem in order to alleviate the problems of the ordinary litigant and resolve their disputes through a process of mediation. Thank you very much.